All right, good morning, Mr. Rose.
Good morning, Judge.
This is the final opportunity for the parties to work out their own resolution, which is always far better off than having this court decide these matters. But the court's informed that the parties cannot reach agreement. Is that correct, Mr. Keeney?
That is correct, Your Honor.
Has all discovery been completed?
At this time, Your Honor, all discovery that could have been completed has been.
Okay. If the court recalls, there was an issue about a credit card debt and the defendant's annuity.
That's correct, Your Honor. That's one of the things that we were talking about. I was successful in getting information about Mr. Rose's annuity account, and Mr. Rose did supply me with images of it as well. Regarding the credit card debt, Your Honor, Mr. Rose and I had agreed to try to work on that simultaneously and try to get the information. I did subpoena the credit accounts, and I only received a response for one of them. And so Mr. Rose today was saying that he was going to make attempts to try to contact them. As the court may remember, this issue regarding the credit cards has been going on since September and November, and that is why we had agreed to try to work on this. And according to Mr. Rose, he has been unable to secure any of those statements. So the outstanding statements are for 2 Capital One credit cards and 1 Bank of America credit card. I was successful in retrieving information for the Kohl's credit card, and it shows that the joint debt owed at the time of separation was $2,899.52.
With respect to the one credit card that you don't have information for, don't the parties receive monthly statements?
I'll allow Mr. Rose to go ahead and answer that. It's my understanding that the parties were receiving electronic statements. Miss Rose at one time did have access to the accounts, so she was the one who paid the majority of them on a regular basis. But when she left, all of Mrs. Rose's saved passwords were deleted, and she no longer had access to the accounts.
All right. So you're all set with Kohl's, and you're suggesting the parties divide and share equally the outstanding balance as of the day of separation. Is that correct?
Correct, Your Honor.
Okay, that's reasonable. But you got the outstanding balance of which card? Capital One or Bank of America?
Neither of those responded, or neither of those produced any figures for me, Your Honor. Capital One stated that they had no record of any accounts owned by Mr. Rose and suggested that I try different subsidiaries. I unfortunately did not have enough time to do research on those subsidiaries and attempt to contact them. And Bank of America at first rejected my first subpoena and then sent me an encrypted email that I was unable to open upon my second subpoena.
Okay. Perhaps those credit cards, there is no indebtedness on those credit cards.
It's possible, Your Honor. Yeah.
Okay. So we could be arguing about nothing.
Correct, Your Honor.
Right. Mr. Rose, do you get electronic statements from Capital One or Bank of America?
No, they go to Rachel's email. So she's the one that goes to Miss.
Hold on. I didn't understand your answer. They go where?
They go to my wife's email address because she set up the digital footprint of it. She set up the digital account. She set up the digital password and all of that. So they all go to her account, her email.
Okay. Apparently she's not receiving those.
The only thing that I get is saying that the balance is outdue. Outstanding balance is outdue in the mail. It doesn't say a number. It doesn't say anything.
Did you provide a copy of those to Mr. Keeney? Does he have an account number?
No, I have not. I thought I emailed them to him after we had the mediation with Mr. Walker, and he said he didn't receive one.
So what's the balance of the Capital One?
It doesn't say on the letter. It just says that there's an outstanding balance.
That's very odd that they say not say balance, but doesn't get an amount. What about the Bank of America?
Both of them. They just say there's an outstanding due balance on them.
Okay, and so you have account numbers then, correct?
Well, there's 4 account numbers and there's like 6 X's on the paper.
Well, what we do at trial
just gives like
that the parties share equally and outstanding balance of those credit cards, whatever they might be. That's how that's addressed.
And I told, yes, sir. And I told Mr. Keeney that I would contact them today, like call them, because I've only been trying to get through it online, and they want me to do a forgotten password online, and I don't have none of that because it goes to her email.
Okay.
That it won't. It don't go to my email.
All right. That in court speed is not really an issue. The credit card that's going to be easily addressed. Parties that share equally the outstanding balance of the data separation. When will reference the data separation? What else that issue, Mr. Keeney? The annuity.
The annuity is not at issue, I don't believe it's at issue, Your Honor. I can go ahead and go over the information I received. The thing that seemed to stonewall the parties were the issue of the marital home. We started off by stating that the parties weren't agreeing to what the equity should be considered, and we were going to decide on a realtor for the parties to use in order to have the home sold. And then there were some discussions about offers that Mr. Rose made regarding the home, and Miss LaPrade, of course, tried mediating and coming in between the values that both of the parties had suggested the home be used. And unfortunately, that's where all communication deteriorated. But Your Honor, I did want to mention there are other issues that we unfortunately were not able to get to today. And so I'm not sure if Your Honor would just prefer that we address everything at trial, and I can brief the court on the issues.
Yes. I tell you, with the real estate, that the court's gonna order that to be sold. I'm telling Mr. Rose that's what can happen at trial. I guarantee you that the court's gonna order that be sold, and then the court will later divide the equity if there is any equity in the home. So that's I'm telling you that if you can't reach your own agreement, that's what's going to happen.
Well, I've tried to give an agreement.
We're going to have a trial within the next 30 days, Mr. Rose. So this has been dragging on too long. It's a short-term marriage, a 4-year marriage. I don't think I've ever had a trial with a 4-year marriage.
And I'm trying to agree with things, but she won't. She's the one that won't agree on it.
All right. Well, it's much easier. We just liquidate everything. Any personal property dispute, we're going to have an auction. We're going to sell the real estate.
Okay, that's if that's what happens. If she don't agree, that's fine.
So it's everything at issue. At one time, I was told the only issue was the annuity and personal property. So everything's at issue then, correct?
Correct, Your Honor. There are some other outstanding debts that Ms. Rose became aware of after our mediation that we have brought to the court's attention, at least on one occasion before, one of them being a cable bill. Last time we were in front of Your Honor, we mentioned that the cable bill the outstanding balance owed is over $1,300, but a good chunk of that, over half of it, is due to unreturned cable property and equipment. And
I do recall that.
And so Your Honor did suggest that Mr. Rose go ahead and return that property. As of earlier this week, Ms. Rose received another bill from them showing that property has not been returned.
All right. All right. Well, you can you'll pay that bill, Mr. Rose. If you have that property, now return it to the cable company, then you're going to buy that property. I'm letting you know that. It's real simple. I do recall the time we were in court, I said, take it back to the cable company to get a credit. But again, if you choose not to do that, then you'll be the owner of that and you'll pay for that bill. All right. So what do you think? Half-day trial, Mr. Keeney? This has gone on way too long. You mediated with Mr. Walker, I believe, Ms. LaPrade. It appears that the court needs to we'll just have a trial. Half day will be sufficient?
Half a day should be sufficient, Your Honor.
Okay. All right.
Thursday, March 7th at 8:30.
How about Thursday, March 7th, 8:30? Are you available, Mr. Keeney?
I am available March 7th, Your Honor.
All right. All right, Mr. Rose, the court's going to have an in-person trial. You're to appear in person March 7th, 2024, 8:30 a.m. We're going to get you divorced then, and we're going to dispose of all property. What the court's suggesting, you keep in contact with Mr. Keeney, try to work things out. The court's available if you reach some agreement in the interim, but if not, I'm going to tell you right now, the home's going to be liquidated. You're going to be responsible for that cable bill, and you own that cable equipment, and the court's going to divide the outstanding balance of all the credit cards that may exist in this world as a result of this divorce action as of the day of separation.
Yes, sir.
I don't know, is custody, is parenting time, is that an issue?
Your Honor, the parties have been following a parenting time schedule now since the first time we were in front of the court. I believe at this point, Ms. Rose is comfortable with the custody agreement for sure, and the parenting time agreement. Mr. Rose, I believe, had mentioned that he was interested in potentially modifying that, but I cannot speak for him.
Okay. What about personal property? Is that still an issue?
Personal property has been taken care of, Your Honor, with the exception of one of the vehicles that was awarded to Mr. Rose.
Okay,
It's my understanding, just for clarification, it's more of a debt issue, Your Honor. The vehicles are in both of the parties' names. The vehicle in question that was awarded to Mr. Rose has been repossessed, and it's negatively affecting Ms. Rose's credit statements.
that vehicle doesn't exist. There's just an outstanding debt for that. Is that correct?
Correct, Your Honor.
And who's the debt to?
The debt's to both of the parties, Your Honor, but Mr. Rose
And
is the
whose
one in
name?
possession.
Who's the creditor?
Rachel Gino.
Northwest Bank.
Okay. All right. The court's going to order that each party submit a brief trial summary 7 days before the trial date. Just setting forth just a 2-pager, Mr. Keeney, setting forth
Understood.
the issues in your client's position. If you know if you can identify the various creditors, if you know the outstanding balance, if they're unknown, you can just simply put unknown. So obviously we've got real estate, unsecured debt, the annuity. Obviously the court's going to order a quad runner for that. That should not be an issue. Unless, of course, it makes sense if the parties can negotiate the global picture rather than piecemeal it. Mr. Rose, for example, Miss Rose, and I don't know if she wants a home. I mean, you work out the equity in that and you try to keep your annuity. But those are things that you need to work out because this court's going to simply divide everything. All right. Do you have any questions, Mr. Rose?
No.
Okay. We'll mail you notice. Trial, it'll be March 7th, 8:30 a.m. in person. You need to appear in person and you need to provide the court with a summary of basically a trial summary 7 days before, name on it before March 1st.
I'll contact Mr. Keeney and try to work things out with him.
Well, Mr. Keeney, if in fact there's some resolution, the court's always available on short notice. We can go on Zoom, and even if you come in, I'm sure the Ms. LaPrade, Mr. Walker, they're always will try to accommodate and be available if you need to talk to them for 15 minutes to wrap up some fine points.
I appreciate that,
Thank
Your
you.
Honor.
All right, that'll conclude this matter. 7 on March 7th at 8:30, if not before. Good morning, Mr. Trucon.
Thank you.
Good morning, Your Honor.
Thank you. The court just called the case. The court noted that this was a pretrial conference being conducted via Zoom and that you were be zooming in representing the plaintiff Rebecca Delmont. Both parties are present. The court has been informed. The parties have reached their own agreement this morning. Is that correct, Mr. Trucon?
It is, Your Honor, it's my understanding.
Wonderful. Who would like to place that agreement on the record?
Certainly. I will, Judge, if I can defer to Amy, she was taking the vast majority of the notes in regard to it. And if I can say this also to your staff and you, as you probably were told, I was diagnosed just a couple of months ago with blood cancer. And so I've been on and off in regard to that, keeping your staff advised. But I'd like to thank both you and all of your staff, Judge, have treated me great during this time period. Thank you.
Well, thank you, and we wish the best for you.
Well, thank you.
So, Ms. Woods-Kovac, can you place on the record what you understand to be the parties' agreement?
I will. Thank you. Your Honor, the parties have a marital home. It is titled in my name, and the mortgage is also in my name, in my client's name, as well as the mortgage, and that will remain in his name. The parties have some land, and all of the land, with the exception of the house, will be sold by the parties. They will cooperate regarding that sale, and after the payment to the USDA and the taxes and all other expenses, they would split the net proceeds equally. The parties have a minor child. They have an agreement to have joint legal custody with physical custody to the mother, and to keep the current parenting time schedule, which is the father having every other weekend from Saturday to Monday and one night a week. They have several items that are going to be sold that would include a side-by-side, a four-wheeler, and 2 snowmobiles, as well as the scrapping of a hauling trailer. They also have a jointly owned backhoe, and my client is going to be giving Miss Delmont $2,000 for her share of the backhoe. The parties have a Jeep, which Mrs. Delmont is driving. She will retain that Jeep and keep the payments current and hold Mr. Delmont harmless and indemnify him on the same. Both parties have retirement accounts and each will keep their own. Mr. Delmont has a 401k that he will retain, and Ms. Delmont has an account that she will retain. Currently, there are child support arrearages of $5,448 from the temporary order that was issued in this case. Beginning February 1st, there will be a new child support, a reduction to $483 a month. The $5,448 in arrears, plus the $2,000 that Mr. Delmont owes for the backhoe, would total $7,448. My client would pay immediately to Mrs. Delmont $3,724. And then the remainder would be due within 60 days. We did not discuss this, but I am assuming that he is going to pay her directly, and the court order will simply extinguish the arrears at the friend of the court, rather than having him pay friend of the court and friend of the court pay Ms. Delmont, because I think that would take an additional amount of time. Both parties have the right to modify child support upon a change of circumstances. Spousal support is forever barred. Each party would pay their own debts. Ms. Delmont would be able to move to her maiden name if she would like to. Tax exemptions would be alternated, with Ms. Delmont taking 2023 and all subsequent odd years, Mr. Delmont having even years. And he would be able to take them so long as he's current by December 31st within 2 months, so that he would be paid by February 1st of each year. He would be able to take the deduction. All other standard provisions in a divorce decree. And I think that is the entirety of the agreement.
Thank you, Ms. Woskowiak. Mr. Trukin, did Ms. Woskowiak accurately state your client's agreement?
I believe she did, Your Honor. If I could clarify just two small points. Number one, that the visitation of the child would be every other weekend from Saturday morning to Monday starting school is correct. However, there also was there that he was to have one day during the week after school for a few hours, not overnight on that during the week, Judge, just a few hours after school. That in fact, if Mr. Delmont does not have a valid license at this time, that in fact a third party will transport the minor child until Mr. Delmont has a valid license and valid insurance on the vehicle. If I can query my client, Your Honor.
First of all, Ms. Woskowiak, are those modifications or clarifications acceptable?
They are. My client does have his license now. That was part of the temporary order, and I do agree that it is not overnight in the midweek.
Thank you. Mr. Trukin, you can begin with Ms. Delmont, please.
Thank you. Ms. Delmont, you've had an occasion to hear what defendant's counsel and I have placed on the record with Judge Braunlich. Is that correct?
Correct.
In regard to those provisions, do you agree with those provisions, and can you live by those provisions?
I do agree.
Are you pregnant at the present time?
I am not.
And you wish this judge to grant a full and complete divorce with the provisions we've spoke about?
I do.
You have lived in Monroe County for at least 10 days prior to filing for divorce, in the state of Michigan 180 days. Is that correct?
Correct.
And again, you are not pregnant at this time?
I am not.
And when you signed the complaint for divorce, ma'am, you indicated to the court and this judge that in fact there had been a breakdown of the objects of matrimony that cannot be preserved, and you wish to have a complete judgment entered today.
Correct.
You understand until the judge signs the final judgment of divorce, you will not be divorced, and that may take some time. But as soon as Judge Braunlich signs that and the orders are placed with a friend of the court, that in fact you would be divorced then.
I understand.
You understand you could have done better, you could have done worse, you could have done about the same if in fact Judge Braunlich would adhere all the provisions, but you're willing to abide by what's been placed on the record today.
I do understand.
Are you satisfied with my consultation and retainment in regard to representing you?
I am.
Thank you, Your Honor.
Thank you, Mr. Trukin. Ms. Waskoviak, do you have any questions for, first of all, for Ms. Delmont?
I don't.
Questions for Mr. Delmont, please?
Yes. State your name for the court, please.
Ryan Delmont.
Is it true that you are a resident of the state of Michigan and that you were 180 days and at least immediately 10 days filing the complaint of divorce?
Yes,
Is it also true that you were married on July 1st in 2015 in Monroe, Michigan?
correct,
And as far as you know, Mrs. Delmont is not pregnant, correct?
correct.
There's one child born of this marriage. That's your daughter, is it Aubrielle?
Yes,
Okay, and she was born in 2015.
yes,
Is it true that there's been a breakdown in the marriage to the extent the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
yes,
Now you listened to me read the agreement on the record, correct?
yes,
Would you say that it's fair that that agreement is as a result of a series of negotiations that have been going on over several days?
yes,
And were you able to fully participate in those negotiations?
I was.
Did you disclose all of your assets?
Yes,
Do you believe that the agreement is in the best interest of your children?
yes,
Do you fully understand the agreement?
I do.
Do you understand that this agreement provides for no spousal support and that it would forever be barred?
Yes,
Are you asking the court to take this agreement, make it a final judgment entry, and enter a final decree of divorce?
I am.
Do you have any questions for me?
I don't.
Do you have any questions for the court?
I don't.
Are you satisfied with my representation in this case?
Yes, thank you.
Do you understand that if we were to go to court, you could get more or less or the same, but you're choosing to enter into an agreement?
I do.
I don't have any other questions.
Thank you, Ms. Waskoviak. Mr. Trukin, do you have any questions of Mr. Delmont?
Not on Mr. Delmont, if I can clarify one thing with counsel for you, Judge, and that was a lease payment on the properties that are going to be sold. If counsel can place that on the record in regard to that and see if both of our clients understand and agree with that.
Understood. In regards to the property that is being sold, there is a farming lease. There are debts that are due. Specifically, there is a $9,000 mortgage payment due in January 1st. There are taxes due in February and September. Total indebtedness due of approximately $18,000. If the property were not to be sold by the end of the year, there is a farming lease where they would be getting income of approximately $7,000. It is the agreement of the parties that that money would go first towards the debt that's on the property. And if it was not necessary for the debt, then those parties would share the lease payment 50-50.
Is that understood and agreeable, Mr. Trukin?
It is, Your Honor.
Okay. Do you want to make further inquiry of the parties relative to that specific issue?
I can, Your Honor. Ms. Delmont, you've heard what counsel has indicated, I've indicated, and the judge has indicated. Is that correct?
Correct, and I agree.
Okay.
And
Thank you.
do you also agree, Mr. Delmont?
I do.
All right. Very well. Who will prepare the judgment?
Normally, I was going to say me, but I'm going to be on vacation next week. So I don't know if Mr. Truchon wants to do it or if you want to wait till I'm back from vacation.
I unfortunately have to go in Monday afternoon to the University of Michigan for treatment. So if I could impose upon counsel to once she gets back from her 1 week vacation or so, Judge, if you could give us 2 or 3 weeks to get together and finalize everything, that'd be great.
I would be happy to do it as long as I get just a little extra time.
That's fine. No problem with the court. Well, we wish you the best, Mr. Truchan. Very well. The court would like to thank and acknowledge Mr. Truchan and Ms. Waskoviak for helping to facilitate ample resolution of this matter. And the court would applaud you, Mrs. Delmont, for reaching your own agreement. Without question, the best resolution of matters of this nature are one in which you both participate and ultimately agree upon. Based, however, on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter by any endorsement bonds of matrimony. Good luck to both of you. That will conclude this pre-trial conference. We can zoom out. Mr. Chushan, we'll keep you in our prayers.
Thank you, Your Honor.
Thank you.
Okay,
Thank you.
For the record, this matter is before the court for continued pretrial conference, subsequent to continued mediation with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Oh, Mr. Patrick, good morning. So you assisted with mediation this morning.
Good morning, Your Honor.
Present this morning is Attorney Robert Tolbert, representing the plaintiff Benjamin Seward. Mr. Seward, Mr. Tolbert are present. Good morning. In addition, Attorney Marie Zagorski is present, representing the defendant Kelly Seward, who is also present. Good morning.
Morning, Your Honor.
Is it court is informed that the parties have reached an agreement? Is that correct?
We have, Your Honor. We're pleased to announce that with the help of Ms. Patrick, over the last 2 days or 2 days sessions, we've come to a final agreement on all the matters on this case.
Wonderful. And who'd like to place that agreement on the record?
I'm happy to do so, Your Honor.
Please, Mr. Tolbert.
Thank you, Your Honor. The parties have agreed there's one minor child in this matter. The parties have been agreed to be awarded joint physical and legal custody of the minor child. Parenting time will be awarded equally, with father receiving every Monday, Tuesday, and Wednesday overnight, mother receiving every Thursday, Friday, and Saturday overnight, and the parties then alternating Sunday overnights on alternating weekends. In terms of exchanges on Sundays, the parties have agreed to meet at Da Capo Coffee and conduct those exchanges at 4 p.m. If there is no school, I believe the parties will be exchanging at 8:30 in the morning, and Da Capo Coffee can also be used for that. Child support, the UCSO and the judgment will reflect child support at 0. The parties have nearly equal overnights with nearly equal incomes. Child support will obviously be reserved. Father plaintiff will continue to provide employer-sponsored health insurance for the minor child. In terms of holiday parenting time, the parties will follow the Monroe County holiday schedule, with the exception that defendant mother will receive the Thanksgiving holiday every year. And the parties have also agreed that summer parenting time will be awarded in 2 non-consecutive weeks. The parties will have 60 days notice to provide the other side with their intentions to exercise that parenting time. Parties are going to equally divide any extraordinary health expenses on behalf of the minor child, and they will also equally divide any extracurricular activity expenses related to dance and gymnastics, and then thereafter any mutually agreed upon extracurricular activity. The parties have already filed their 2023 taxes jointly. They're anticipating an approximate $2,700 refund. That refund will be equally shared between the parties. Thereafter, the parties will alternate claiming the minor child on their taxes, with mother receiving the exemption in even years and father receiving the exemption in odd years. Parties have both agreed to bar spousal support to the other, and the judgment will contain the required statutory language related to that. In terms of the property settlement, defendant mother is going to be awarded the marital home located at that'll be awarded to her free and clear. Father plaintiff will be awarded $20,000, will receive a $20,000 payment from mother for his portion of the equity in the home. That will be paid to him within 90 days of entry of the judgment. If that payment is not made within 90 days, the parties agree that the home will be sold, and mother will receive the proceeds minus the $20,000 that's owed to plaintiff. At the point in time where plaintiff receives the $20,000 payment, he will sign a quitclaim deed releasing his rights to the home. There is some property in the home that needs to be divided. Plaintiff is going to be awarded the freezer in the garage, there are tools, a workbench, a gun safe with guns, and then weight equipment. Those are awarded to father. Plaintiff, he will have until August 23rd, 2024 to remove those heavy items from the home. There's an elliptical that's also in the basement that's going to be awarded to defendant at this time. The parties have agreed to extend status quo until February 23rd, 2024, at which time father will be moving out of the home and mother defendant will have exclusive use of the home at that time. The parties have several bank accounts. They have joint accounts through Monroe County Community Credit Union. Those contents and the accounts will be awarded to plaintiff. Defendant has agreed to remove her name from those accounts. Defendant has bank accounts through Directions Credit Union, a checking and savings that are going to be awarded to her with the contents provided. Mother defendant also has an HSA account that's going to be awarded to her. The parties, father plaintiff has a pension through the city of Detroit that has been awarded to him as his sole and separate property. There are several 403B and IRA plans in the name of defendant mother. Those are going to be awarded to her outright as well. Plaintiff father has accrued sick and vacation time that has a cash value. Though that sick time and vacation time is also awarded to plaintiff father. The parties have life insurance policies. There's a whole life policy through Alliance Life Insurance in the name of plaintiff father. That is going to be awarded 100% to him. I believe defendant mother has a Sun Life insurance policy. It's a term policy that'll be awarded to her. Parties have agreed that the minor child will be named as the beneficiary to an employer-based life insurance policy that's separate through the city of Detroit that is a benefit of my client's employment. I don't know if I mentioned this already, Your Honor, but father will continue to carry his employer-sponsored health insurance on behalf of the minor child. The parties have vehicles. There's a 2019 Dodge Ram that is going to be awarded to plaintiff father with all the debts he'll indemnify and hold mom harmless of any of the debts associated with that vehicle. Mother defendant has a 2015 Jeep Cherokee in her name, will be awarded to her as her sole and separate property, and plaintiff will be indemnified and held harmless of anything related to that. The parties have a series of credit cards. They're going to keep the credit cards and the balances associated that are in their respective names. The parties agree not to incur any other expenses on the others' cards after today. And I believe both parties have some student loans that will obviously be awarded to them in their respective names. There is a kids account at Directions Credit Union in the name of mother defendant that is being held, I believe, for her niece. She's going to be awarded that account as her sole and separate property as well. I believe that is a complete recitation of the parties' agreement, Your Honor.
Thank you, Mr. Tolbert. Mr. Gorski, did Mr. Tolbert accurately state your client's agreement?
Yeah, yes, with a couple of additions. The exemptions that the parties are sharing in alternating years are based on the tax year and not the calendar year. Each party is going to pay their own attorney fees. The parties have agreed that they'll both be present to withdraw any money from the minor child's account. And just to clarify, plaintiff father goes, I think, hunting for the week of Thanksgiving, so that Thanksgiving holiday generally incorporates that week. And with those clarifications, Mr. Tolbert did accurately state the parties' agreement.
Mr. Tolbert, you can begin with Mr. Seward, please.
Sure. Mr. Seward, did you file a complaint for divorce in this matter?
Yes.
At the time you filed the complaint, were you a resident of the state of Michigan for at least 180 days?
Yes.
And a resident of the county of Monroe for at least 10 days?
Yes.
Did you allege in your complaint that there's been a breakdown in the marital relationship to the extent that the objects of matrimony have been broken and there's no likelihood that they could be repaired?
Yes.
And that was true at the time you filed the complaint?
Yes.
And remains true today?
Yes.
If the judge could not grant your divorce today, could you continue to live with the defendant going forward as husband and wife?
No.
Okay. And I want to confirm there's one minor child between the both of you?
Yes.
And is it your understanding that the defendant is not pregnant at this time?
Yes.
You heard the recitation of the agreement that was made at mediation today after 3 sessions?
Yes.
You understand, you agree to be bound by those terms?
Yes.
You understand that those terms are final and binding, you cannot change your mind at any point?
Yes.
You understand by agreeing to all these terms that were set on the record today, that you waive your right to trial, which the court could have been the determiner of all of those issues, and you could have done better, worse, or the same than you've done today.
Yes.
And you intend to sign a final judgment in divorce containing the the agreement that was placed on the record today?
Yes.
You understand that, let me scratch up. You heard the parenting time and custody terms that were placed on the record, correct?
Yes.
You believe that those, that agreement is in the best interest of your child?
Yes.
And you understand that spousal support has been barred in this matter. You cannot, you won't be claiming any spousal support, and defendant won't be claiming any spousal support from you. You both will not be able to come back at a later time and ask the court for spousal support. It is forever barred.
Yes.
Do you have any questions for me or for the court today?
No.
And are you satisfied with my services throughout the
Yes.
pendency of this matter? Your Honor, no further questions.
Thank you, Mr. Tolbert. Mr. Gorski, do you have any questions, first of all, for Mr. Seward?
No, thank you.
Questions for Ms. Seward, please?
You heard your husband's testimony this morning.
Yes,
Was it accurate?
yes,
And can you confirm that you are not pregnant?
yes.
You are not
I
pregnant,
am
correct?
not pregnant.
Okay. And similarly, you've participated in these negotiations, correct?
Yes,
You understand that if we asked the court to, the court would take evidence and could make a different disposition of the property, custody, and parenting time.
yes,
It could have been better, worse, could have been about the same.
yes,
Okay. And with respect to custody and parenting time, do you believe this to be in Ella's best interests?
yes,
And you will continue to facilitate a relationship between Ella and her father?
yes,
And with respect to the property settlement, you believe that it's fair and equitable?
yes,
Do you have any questions about it?
No.
You understand that the property settlement will be final and binding if the court accepts it today?
yes,
You understand, and we've discussed the fact that the court will retain jurisdiction over the issues concerning Ella and will always act in her best interests?
yes,
Have you disclosed all of your assets?
yes.
Are you asking the court to adopt this agreement?
Yeah.
Do you have any questions of me? Thank you. That's all I have, Your Honor.
Thank you, Ms. Gorski. Mr. Tolbert, do you have any questions of Ms. Seward?
No, Your Honor, thank you.
You'll prepare the judgment, Mr. Tolbert?
I will, Your Honor.
Very well. I would like to thank and acknowledge Ms. Patrick for her assistance in helping facilitate ample resolution.
Actually, I don't know. I'm not confident one way or the other.
I'm thinking we didn't.
Oh, I think we did because
I don't remember.
well, I have,
I guess Judge will know, and I'm sure it's in his notes there.
sure, I have a proofs list in this folder, and I usually only prep that when I need them.
I
guess I
can't
don't
remember.
remember.
I can't remember if Judge made us do that or not last time. That's all.
Yeah, I can't remember either.
And if we haven't done it, like I know both Matthew and Rebecca, it's just simply asking if you live in the county for 10 days, state of Michigan for 180 days, that you're married in 2003, that you have a child together, and the marriage broken down can be preserved. I know, again, we talked about the agreement itself. I don't think we can put on the record today based on the bankruptcy, but those questions may want us to ask those 6 questions, whatever there is.
For the record, this matter is before the court for continued pretrial conference subsequent to continued mediation. This hearing is being conducted via Zoom. Present is Attorney Jason Kazmarek representing the plaintiff, Matthew Bradley, and Mr. Bradley is present. In addition, Attorney Alex Goldman is present representing the defendant, Rebecca Bradley, and Ms. Bradley is present. Good afternoon, everyone.
Good afternoon.
The court has been informed the parties have made progress in their mediation with Mr. Walker, but do not have a full and complete agreement. Is that correct?
It's largely a full agreement. The problem is the parties are currently in a conversion from a Chapter 13 to a Chapter 7, and I don't believe we can put that agreement on the record based on their pending bankruptcy. There's only one term to really be discussed in the future, which I think the parties are going to discuss and decide before we come back, reconvene.
Okay. Well, it's up to the parties. I think the court can enter a judgment of divorce, but again, we have to reserve some of the property issues. I think because the bankruptcy trustee has control over the property, correct?
Correct.
But if the parties are not anxious to get married or anything, I suppose we could just take the proofs today. If you want, we put whatever partial or full agreement you want to put on the record, Mr. Kazmarek and Mr. Goldman. What are your thoughts?
I'll defer to Jason.
I don't know. In fact, I think the parties were expecting not to put it on today, but I mean, we could certainly put the proofs on today if we put the whole agreement on or not. I don't want to mess up anything with their pending bankruptcy. That's all.
That's fine. Obviously, if in fact you want to tie down the agreement so people don't change their mind after talking to their neighbor or their sibling, then we can secure that agreement, but it can always be subject to the approval of the bankruptcy trustee. You can do that as well. It all depends. So sometimes people, they'll talk with their brother or their sister and, oh, you should never agree to that. And this is really between the parties. So Mr. Kazmarek and Mr. Goldman, if in fact you think we want to put on the record, we could do that. At least these parties can't then change their mind next week. We can always make any agreement subject to the approval of the bankruptcy trustee.
Matt and Rebecca, if you're okay with that, we can put the agreement we have on the record today and just reserve that one term. If you
That's fine. I'm okay with that.
Rebecca, you okay with that?
Yeah, that's fine.
All right.
So the parties are going to share. Oh, I think you probably took better notes than me, but I could come pretty
I'm
close.
just reading out. I'm reading out the prior order. Plaintiff father will have every Wednesday and Thursday and every other weekend. Defendant mother will have every Monday and Tuesday and every other weekend. Another parenting time as parties can agree. Clinical holiday schedule will apply, or if parties can agree. There is currently, I'm sorry. In addition to that, we have another. The parties had considered. I'll just bring this up now. A right of first refusal beyond. There's a discussion between 5 hours, 8 hours, or not having it at all. That term is they're going to discuss and hopefully have an agreement on, but that has not been agreed upon yet. So that's the current parenting time order. Did I miss anything with parenting time? Two of you?
No.
That's the current order. Okay. For child support, that'll be $374 per month. That's broken down: $394 base support, a $50 offset for health insurance, $30 ordinary medical for a total of $374 a month. Effective date will be March 1st, 2024. And that's based on 182.5 overnights to each party. Spousal support will be $800 per month, modifiable as to amount that will be terminated upon remarriage or death of either party, effective 3/1/24. And that'll be for 6 years, for 72 months. For the child, the school district will remain the airport school district. Regarding tax deductions and credits, Matthew will claim odd years, Rebecca will claim even years for that minor child. Regarding property, there is a marital home located at 113. Plaintiff Matthew will keep that property and will hold Rebecca harmless for any debt associated with the property. There's a few vehicles. The defendant Rebecca will keep a 2013 Town and Country and a 2001 Escort. Plaintiff Matthew will keep a 2019 Blazer, whose party will be responsible for any debt associated with the vehicles, hold the other harmless for any debt. There is a $1,000 offset that Matthew is going to pay Rebecca for difference in values of vehicles and home value. That'll be paid from Matthew to Rebecca by May 24th, 2024. Regarding other personal property, the parties have created some lists. Those lists will be incorporated in the judgment. In addition to the $1,000 offset, plaintiff Matthew will pay Rebecca $250 in addition to offset personal property. That includes some guns that Matthew is keeping. But again, that additional $250 is going to be paid by May 24th, 2024. So in total, Matthew or Rebecca, $1,250 by 5/24/24. Regarding debt, each party will keep any debt in their own name. Again, this is all pursuant to the bankruptcy being successful. Bank accounts, each party will keep their own. And retirement accounts, Rebecca will get 1/2 of the marital portion of Matthew's 401k. Defendant's attorney will facilitate the preparation as he gets that without cost. And so basically, defendant will bear the cost of the quadro through her attorney legal services. And I think that's the total agreement of the parties. Again, this is all pursuant to the bankruptcy going through.
Certainly, that's noted. Thank you, Mr. Kazmarek. Just with respect to spousal support is not awarded to the defendant, and that's forever barred, correct?
Correct.
But in terms of spousal support is awarded to, I'm sorry, the other way around. Spousal support to the plaintiff is not awarded, that's forever barred. But spousal support to the defendant wife is awarded. That's $800 per month for 72 months, correct?
Correct.
And I'm sorry, did you say that's subject to modification?
Yes. It's modifiable.
Not
And again, that
modifiable in terms
effective
of amount as well as duration.
I mean, I guess yes, because if he went to disabled or something, I guess it could end. So I would say yes.
As to amount as well as duration. Okay. All right. So with that clarification, Mr. Goldman, did Mr. Kazmarek accurately state your client's agreement subject to bankruptcy trustee approval?
Yes, Your Honor.
All right. When's anticipated? Will there be? Do you anticipate any order in terms of the spouse's support and child support? Are you going to wait? Will that commence or sometime in the future?
There's about a $26 difference right now between what he's currently paying and the change. So actually his child support reduces, his spousal support goes up. So I don't plan on doing any temporary order changes, put it that way.
Okay. There's already an order in place. Oh, I do see that. Yes. Temporary spot. Okay. Thank you, Mr. Kazmarek, for that clarification. Right, Mr. Kazmarek, if you can be with Mr. Bradley, please.
Yes, sir. Matthew, could you please state your name?
Matthew David Bradley.
And at the time of the filing of the complaint for divorce, did you reside in Monroe County for at least 10 days?
Yes.
In the state of Michigan for at least 180 days?
Yes.
And you were married to your wife on or about May 9th, 2003, is that correct?
That's correct.
You have one child together?
One minor child currently. We have 3 total children.
Yeah, one minor child currently?
Right.
Is that correct? Yes, okay.
Yes.
And you don't believe Rebecca's pregnant, is that correct?
That's correct.
And you believe there's been a breakdown of the marriage that cannot be preserved, is that correct?
That's correct.
Okay. And you've heard the agreement placed on the record today. Is that your agreement pending bankruptcy? Is that correct?
That's correct.
And you were involved in a couple lengthy mediations. You understand that the agreement put on the record today is going to be a final resolution to your divorce. There's no need for a trial or anything like that. Again, this is all pending the bankruptcy that is currently involved with federal court. Is that correct?
That's correct.
Sorry, is that confusing?
I think I understand. Yeah.
So, well, you understand you could have gone to trial. We could have got more, could have got less. With the terms stand on the record today are your full and final agreement subject to bankruptcy court approval.
Correct.
Okay. I have no further questions.
Thank you, Mr. Kazmarek. Mr. Goldman, do you have any questions? First of all, for Mr. Bradley.
No, Your Honor.
And I'm sorry, Mr. Kazmarek, you did establish jurisdiction. Is that correct?
I did.
Okay, thank you. All right, Mr. Goldman, do you have any questions for Ms. Bradley?
Yes, Your Honor. Rebecca, please state your name.
Rebecca Lynn Bradley.
Did you hear all the questions that Mr. Kazmarek asked Mr. Bradley?
I did.
Do you agree with all of the answers?
I do.
Have you lived in Michigan for 6 months? Had you lived in Michigan for 6 months prior to the filing of divorce?
Yes.
And had you lived in Monroe County for 10 days previous?
Yes.
Is there any possibility that you may be pregnant today?
No.
Did you understand the agreement that Mr. Kazmarek read?
Yes.
Do you have any questions about that agreement?
I do actually. He mentioned something about the spousal support being terminated if either of us got remarried. Is that accurate?
No, Matthew can remarry and still owes it to you.
Okay, I just wanted clarification on that. Okay.
I think if Rebecca remarries, then there would be subject to termination, correct?
Yes, of course.
Correct.
That's understandable.
I think I said both deaths, basically.
Okay.
Okay, I just wanted clarification. I just wanted to make sure. I was like, wait a minute.
I'm glad you did. Do you have any other questions like that?
No, that is all.
Are you under the influence of anything that would affect your ability to understand this agreement?
No.
Do you believe this agreement is fair and equitable?
I do.
And do you agree with this agreement pending the discharge of bankruptcy?
I do.
Do you understand that you had the right to go to trial?
I do.
And that you are giving up that right by agreeing to this?
I do.
Do you believe this agreement is in the best interest of your child?
I do.
Nothing further, Your Honor.
Thank you, Mr. Goldman. Mr. Kazmarek, do you have any questions of Ms. Bradley?
No questions, thank you.
Okay. So once again, just make sure the courts understands the parties will mediate with Ms. Walker again on April 4th, 2024 at 1:30 p.m. Is that correct?
If needed. So again, if the bankruptcy resolves, we may just submit some kind of consent judgment. If needed, we can reconvene with Mr. Walker on that date. Yes.
Okay. So, what the courts are trying to do is send out a notice of a continued pretrial conference for that date, so the file's available in case you need to put anything else on the record. And if in fact the judgment is entered prior thereto, you can simply vacate that pretrial. Is that agreeable?
Yes, sir.
All right, thank you there, court would, and then again, the court would note for the record that this property settlement agreement, even though the parties will be bound by it, is subject to the approval of the bankruptcy trustee. Court would like to thank and acknowledge Mr. Walker for his assistance in helping facilitate progress today, as well as, of course, attorneys Kazmarek and Goman. And the court would applaud you, Miss Bradley, for reaching your own agreement. It's wonderful you can co-parent your remaining minor child. Without question, the best resolution of a case of this nature is one in which you both participate as you have today and agreed upon. Far better off than having the court decide these matters. Keep in mind, you will not be divorced till the court signs written judgment. So it sounds like we'll have to wait till we get final bankruptcy approval before that judgment is entered. Unless you tell your attorneys, well, I get divorced before then. And we'd have to put language in the judgment that the property settlement is subject to property bankruptcy trustee. In any event, thank you, Mr. Goldman and Mr. Kazmarek. Based upon the testimony that's been presented this afternoon, as well as plain filing this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Ultimately, upon receipt of the proposed judgment, fully approved by the parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter to any divorce from bonds of matrimony. Good luck to both of you. That will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Good day.
Welcome. For the record, this matter is before the court for the purpose of reviewing parenting time. Subsequent parties have engaged in mediation with Ms. LaPrade this afternoon. Present are two very capable family law practitioners. Actually, Ms. Patrick is present, so the parties meeting with Ms. Patrick. Present for the Zoom hearing is Attorney Marie Zagorski, representing the plaintiff father Matt McCart. Mr. McCart is present. In addition, Attorney Scott Longton is present, representing the defendant mother Anna Goins, and Ms. Goins is present. Of course, informed the parties have not reached their own agreement with the capable assistance of Ms. Patrick, Mr. Longton, and Ms. Zagorski.
That's correct, Your Honor. Unfortunately, it was an unsuccessful mediation.
Okay. So they want the court to raise their child?
Your Honor, I don't know if they want that, but there's definitely a impasse in their beliefs as it relates to the child. So yes, there is going to be some significant input from the court in the near future. I believe we are at an impasse to the point where, unfortunately, I would ask the court to schedule this for trial so that all parties can present all evidence as it relates to the issues on point.
So the issues are custody as well as parenting time. Is that correct?
Yes, Your Honor. Custody, parenting time, and child support. Child support is still not cycling in this matter. There was a good cause placed with DHS. Therefore, unfortunately, Ms. Patrick's office cannot process a income withholding order. That does not prevent Your Honor from ordering direct payments, but through the DHS system, it cannot be processed.
So Ms. Goins is not receiving any child support right now?
None, Your Honor. The initial recommendation of the front of the court, and Your Honor, even at that rate, the front of the court cannot even mail out a child support recommendation because they can't process it in their system.
Okay. But there has been an amount ordered, is that correct?
There is a unofficial recommendation sitting on Ms. Patrick's desk that she's not able to process, is my understanding. Ms. Patrick, if you please elaborate additional.
So is did Ms. Patrick share the recommendation with you, Ms. Zagorski?
Yes, and we talked about child support extensively today. Mr. Longton has engaged in discovery, and I've provided tax returns and business documents. The problem is that Ms. Goins went to DHHS and claimed to be too terrified of my client for DHHS to take any action. So even though this child is on Medicaid, and to be clear, Judge, my client historically has paid voluntarily. The parties had agreed to $200 a month well before I filed this action. And I have a transcript from Judge Lohmeyer when mom had the child's last name changed, where she acknowledged that my client has paid support voluntarily. Ms. Patrick can't do it because of Ms. Goins's action. And there's nothing my client can do about that. Ms. Goins took that action on her own.
Well, and to be clear, Your Honor, that action was taken when the child was an infant, approximately 3.5 years ago. So, you know, to put that on my client, not knowing that that was the result for this purpose, I don't think would be appropriate.
Any reason why the court cannot enter a support order today in order that that be paid directly?
Your Honor, there is my understanding not an issue with that. Ms. Patrick, I apologize.
No, you're okay, Your Honor. Your Honor, we did not agree on the amount, and Mr. Longton is correct. If the court orders the amount, then it would have to be paid directly. It cannot be programmed by the front of the court. The system is owned by DHHS, as the court is well aware of. And until that good cause is lifted off the case by the support specialist or caseworker at DHHS, the front of the court's hands are tied as to the MICE system.
So how does that get lifted? Does Ms. Goins have to follow up with that agency?
That's correct, Your Honor. And Mr. Longton had a conversation with his client and did instruct her on how to do that. She'll have to contact her caseworker at DHHS.
Okay. I have no idea. Would that take months, or can that be done in a matter of weeks?
Honestly, Your Honor, it depends on the caseworker. Sometimes it can be done as in little as 2 weeks, but I've seen it take at least 3 to 4 months. It depends on the caseworker you're dealing with at DHHS.
Okay. Well, the court believes we should get a support order entered today, and the court's inclined to order child support today, and that Mr. McCart pay that directly until such time as an income withholding order can be entered. What's your recommendation, Ms. Patrick?
Well, the recommendation that Mr. Longton was talking about that was done back in June of 2023 was only for $4 a month. We had discussed today some figures that I was giving, and then the range there would have been anywhere from $300 to $425 a month. So there were a couple offers made, but I don't believe we have an agreement on that.
Okay. Do we need a formal investigation on child support?
We can do that, Your Honor. I believe, though, I think both parties are going to agree. The front of the court is going to be a little hampered in that Ms. Zagorski's client is self-employed, so that's going to be a little tricky for the front of the court, but the front of the court can do an investigation, Your Honor.
Ms. Zagorski, any thoughts?
Your Honor,
Parties cannot agree.
Ms. Zagorski, if I can, without getting into specifics, your client had made an offer of a specific dollar amount. My client would be agreeable to that amount to at least resolve that issue today, if that dollar amount is still an option.
My client offered it, and I'm happy to tell you, Your Honor, my client offered $300 a month. That was with the default 75 overnights. My client at $30,000, Ms. Goins at $40,000, when in fact she makes $52,000. I thought that was fair. I don't think that Mr. Longton's review of my client's financials have revealed any smoking gun of big money out there. But if it did, I'm sure he would bring that to my attention. He has subpoenas out right now, and if he finds something, I'm very confident he'd share it with me. So we would pay $300. I don't want to set my client up to fail in terms of, you know, it's counterintuitive to me that Ms. Goins has claimed that she's so afraid of Mr. McCart that now Mr. McCart is going to have more contact via the money. So I would ask Mr. Longton to provide me with banking information so that he can transfer that money or do direct deposit. I don't want him to have to give her cash. We're already exchanging this child at the sheriff's department. So I think it's best for everybody if we have some other way for that money to transfer.
Your Honor, that would be agreeable. We can provide an account for that to occur through.
Okay, so $300 per month is agreeable with Ms. Goins?
That's agreeable to you?
How much?
$300 per month. And again, as Ms. Zagorski said, if there is something that I uncover during the financial subpoenas that are out there, I'll bring that to her attention and we'll readdress child support. Is that agreeable to you?
No, it doesn't look like you have the options.
No, you don't. Not at this point.
Sounds like it's not agreeable, then I guess we'll delay that issue for a future date then.
Okay. Your Honor, I would ask you to just delay that for a future date then until I can get the subpoena responses.
Okay. Child's 3 years old. Did the parties complete the small program as previously ordered by the court?
My client has.
My client did also, Your Honor.
I believe that is correct, Your Honor. I believe that those are in the.
I was going to say, I think we addressed that a few hearings ago, Your Honor, with the front of the court staff.
Okay, and currently dad's parenting time is unsupervised, as the parties can agree. Is that correct?
Your Honor, he currently has every Tuesday and Thursday from 4 to 7 and every other Saturday from 12 to 5. And I know we're headed toward an evidentiary hearing, but I just want to be clear to the court that my clients, well, strike that. Never mind.
All discovery, I'm sorry, you need some additional time for discovery, Mr. Longton?
Just briefly, Your Honor, just the subpoenas that are outstanding really is all I'm waiting for, and hopefully that will be the resolution of the financial issues. Your Honor, I would just ask for 25 days, 3 weeks to complete that.
Mr. Longton, can you get me the child's medical records from the ER visit voluntarily, or do I need 28 days to do formal discovery to your client on that?
Your Honor, Ms. Zagorski, why don't we do this? Your Honor, if we can just do the 28 days for formal discovery just in case. Okay. However, I am going to ask that you give me the ER visit for my records also to share with Ms. Zagorski, okay?
It was
It was a urgent care, I believe.
No, it was his pediatrician at the University of Michigan, Celine.
Okay. Did you hear that, Ms. Zagorski? It was a pediatrician appointment.
Can you, Scott, could you just email me that doctor's name so I can get a subpoena out?
Yes.
Matt, I'll need a release from you as the child's father.
Okay.
The person's doing the factory. But that's not who investigated it. It was a different doctor.
What practice was it with? U of M, Celine, what?
Health, pediatrics. It's out.
Ms. Zagorski, was the U of M Celine Pediatrics
Okay.
office.
How long do you anticipate the hearing? Half day?
Yeah. Your Honor. No, I would a whole day probably, Your Honor.
So we have testimony from third parties, and that's more than just the two parents?
No, not really, Your Honor. I mean, maybe, but realistically, I have 2 3-ring binders that are 3.5 inches thick of police reports and other documentation.
I'll be objecting to a lot of it because it's not relevant or it's stale, but Judge, I have DHHS to verify that Ms. Goins called CPS and they closed their case. I've got the Family Counseling and Shelter Services supervisor of the supervised parenting time, my client, his girlfriend, and his parents. So I alone have 6 or 7 people.
These parties must be very well off financially to afford to litigate these issues.
Judge, they are not.
Unfortunate.
And this is what I was going to tell the court earlier. My client, if we have a hearing, I think the court would say that this child should spend an equal amount of time in both parents' care, because this child has the right to know both parents. My client's not even asking for that. What he's seeking to get out of a hearing is every other weekend and dinner on Wednesday nights. And I think the court will be hard pressed not to give a child access to his father every other weekend.
Right now, there's no overnights, correct? So he's asking
Correct.
for overnights. Yeah, well, at some point in time, he's got to have overnights. So yes, it could be hard pressed to have pretty strong evidence that Mr. McCart's a danger to the child to prohibit, to not permit overnights. Ms. Goins.
And Your Honor, my client understands that. I would remind the court that it has only been since the filing of this action that Mr. McCart has exercised some type of regular parenting time contact with the child leading up to this action. It was very sporadic, as he testified to during the name change hearing.
I didn't testify to that.
So with that said, Your Honor, also given the domestic violence that has occurred in this case, this is one of those difficult cases where I can understand Ms. Goins's position in her concerns for the safety of the child with Mr. McCart. So, Your Honor, I do, as you know, I always take to heart your statements. I will have further communication and discussions with my client. But I look at this case as this child is just now becoming acclimated to Mr. McCart, and the child is not an infant. This child is 3 years old and has really never been around Mr. McCart leading up to this action being filed. So I don't think that this is a equal parenting time case under any circumstances, as Ms. Ligorski has stated, but I do believe that there are some concerns that my client has that are legitimate. That's why the issue of legal custody has been reserved, because of the domestic violence. So
I'm sorry, Mr. Longton, legal custody was ordered on June 23rd of last year.
On an interim basis, yes.
And that has continued through today. This action was filed because Ms. Goins was dictating the relationship between the child and his father. But whatever, I'll leave it to your proofs.
Yeah. The court recognizes on a temporary basis, and I think with joint legal physical to mom, this court does not get caught up on the issue of physical custody. So I can tell you the hearing, unless there's significant evidence contrary, the court's going to order joint legal. These parties should be able to share equally major decision concerning the welfare of this child. So as far as this court is concerned, no issues at a parenting time. And it doesn't sound like alternating weekends and one evening during the week is equal parenting time, Mr. Longton. So in any event, okay, we can give you a one-day evidentiary hearing. It'll be in person. And you should, exchange witness lists, 7 days before the hearing? How much time do you need before the hearing for each of you to exchange witness lists?
Your Honor, could we do the 14 days before the hearing?
Ms. Gorski?
That's fine.
Okay. I believe we'll probably be looking at June. How about May 2nd?
I am available.
Thursday.
That's fine. That works.
All right. All right, to May 2nd, 2024, 8:30 a.m. in person. Parties shall exchange witness lists and courtesy copy to the court. I guess exhibit and witness lists 14 days prior thereto. And finally, the court would encourage the parties to continue their discussions so that the two parents can make these decisions rather than a third party, the court, who does not know River, making these decisions.